Even though the preliminary submissions of the respondent on the leadership structure is that no leadership structure exists which can be a basis for rendering any finding on the preliminary issue, the respondents in the alternative relied on the resolution dated 30th June 2023, whereby Shri Ajit Pawar was elected as the president of the NCP. Relying on the resolution, the respondent submitted that the constituent members of the leadership structure were changed by electing Shri Ajit Pawar as the president of the party, and if any leadership structure must be considered, then it must be in which Shri Ajit Pawar is the president. The petitioner disputed the aforesaid claim by submitting that the alleged event of 30th June 2022, as claimed by the respondent, are inherently improbable, and the election of Shri Ajit Pawar was not in accordance with the procedure prescribed by the NCP constitutions. Findings and conclusion. At the very outset, I wish to make certain observations. Even though both the parties have submitted, probably owing to the tenor of the observations of the Honorable Supreme Court, that preliminary issue has to be decided on a prima facie assessment of material on record. In fact, both the parties have, contrary to their own submissions, led extensive evidence to buttress their respective arguments with facts in respect of the relevant leadership structure. Be that as it may, I am not inclined to diverge from the Honorable Supreme Court's directives to consider evidence of both parties in respect of validity and or illegality of organizational stroke leadership structure, in which it was this position of prima facie assessment that I adopted in my final order dated 10 January 2023, when I proceeded to decide the disqualification petition number 1 to 16 of 2022, the ShivSena disqualification matter, where I have already held that jurisdiction under the 10th schedule only mandates a prima facie adjudication as to what leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not leadership structure was pursuant to a validly held election. It is a matter of fact that till 29 June 2023, there has been no contemporaneous challenge to the leadership of Shri Sharad Pawar as the party president. However, the said position was sought to be altered by the Ajit Pawar faction by way of the resolution dated 30th June 2023. Thus, prima facie, as on 30th June 2023, there existed two parallel claims in respect of the NCP leadership, the one according to the petitioner claiming Shri Sharad Pawar is the party president, and the other one claimed by the respondents where Shri Ajit Pawar is the party president. In order to try and demonstrate that their separate claims to the leadership of the party by their respective presidents, both the parties have led oral and documentary evidence and argued exhaustively. Both the parties claim that it is their leader who was validly elected according to the NCP constitution, and the claim of the other side therefore cannot be entertained. Furthermore, both parties claim that other side's claim as to the leader's election as the party president was not accordance with the NCP constitution. As noted earlier, under the 10th schedule, while deciding the preliminary issue, I cannot go into the validity and or legality of elections to the leadership. I am therefore confronted with the rival assertions which clearly indicate the existence of two persons claiming leadership of the party. It is to be noted at this juncture that the respondent number 1 to 9 of petition number 1 of 2023 joined the government on 2nd July 2023. The resolution electing Shri Ajit Pawar came to be passed on 30th June 2023. This leads to a peculiar situation where there are seen to exist two parallel leadership structures and two party presidents prior to the alleged conduct attracting disqualification. Undoubtedly, the rival parties have tried to lead evidence to justify their opposing stand about the validity of the election of their leader to the post of president. They have tried to show how their separate processes of election were justified by the NCP constitution. I am not inclined to go into their evidence or appreciate their evidence-based arguments, because this would lead deciding whether the rival elections were in keeping with the constitution and the rules, and whether factually Shri Sharad Pawar or Shri Ajit Pawar were validly elected, or whether in fact Shri Sharad Pawar had resigned at the relevant time. I possess no jurisdiction to issue any such declaratory orders. In the absence of such jurisdiction, which is certainly not available under the 10th schedule of the Constitution, or the wherewithal to examine the correctness, validity and legality of parallel claims of valid stroke legal elections, I need not and cannot undertake such an inquiry. Thus, for this reason alone, relying on the test of organizational stroke leadership structure to examine the two parallel rival claims in respect of the leadership about the post of party president, I cannot arrive at even a prima facie decision on the preliminary issue. Irrespective of my findings herein above, if the leadership structure relied on by the petitioner is looked at even for ascertaining the prima facie position, it is seen that it cannot form the basis for determining the preliminary issue for the following reasons. The petitioner's reliance on majority in NCP Working Committee cannot be taken into account for determining the preliminary issue, as the composition of the NCP Working Committee relied by the petitioner is not in conformity with the NCP Constitution. Article 21 of the NCP Constitution, read with NCP rules, provides that the highest executive authority of the NCP is NCP Working Committee, which consists of 1. The President of the party, 2. Leader of the party in Parliament, and 3. 23 other members, of whom 12 members are elected by the National Committee and rest are appointed by the President. A perusal of the documents relied on by the petitioner to show the composition of the NCP Working Committee indicates that the NCP Working Committee had 28 members, whereas the NCP Constitution provides for only maximum 25 members. The said document shows 16 permanent invitees, whereas the NCP Constitution does not provide for any permanent invitees. The petitioner